Well, good afternoon, everyone. There are some brave souls, pardon me, and the brave souls are those who think they either do know something about insurance or would like to learn something about insurance, because it's one of our more complicated issues we deal with as municipal administrators or leaders, elected officials in Saskatchewan, and it's great to see you here. It's like church. If I would have been able to go this morning. I sit at the very back in church, and I see you guys are following my lead by sitting in the back, except even Stephen's sitting at the back, so I appreciate that. So when we talk and spew some saliva, nobody will get it, because this is such an interesting and exciting topic, insurance. Yeah, right. Well, anyway, welcome to SUMA Convention, and this is the first of a number of education sessions that we, the board, provide for you, SUMA members, and for me as well, to learn and to experience different things. And we thought this might be a worthy and wise topic to discuss among ourselves and with three experts that we have with us today at the panel. I'll introduce them in just a moment. My name is Barry Gunther. I'm the Vice President of Villages, Resort Villages, and Northern Municipalities. Have been for some time, and still every year find something new to learn, some new people to meet, and some acquaintances to renew. I know many of the faces in the room, but just to give your fellow delegates an opportunity to see how many of you are here at the SUMA Convention for the first time. Raise your hands. A few. And this is your second convention? Okay, so thank you for that. We're preaching then to those of you who have been here a while, but the insurance business is an evolving business, changes from year to year, and with the growth of SUMA Assure, today's event sponsor, it's a pleasure to welcome you and to introduce this session. As I do, one of the criteria that the host facility has asked us to do is to remind you and to educate you, first of all, on some emergency preparedness. This being an insurance seminar, it's pretty appropriate, I think, that we start off on the right foot, and that is TCU Place have the following bit of information that they ask us to provide to you in case of an emergency in this facility. And as such, as I do that, I can remind you that if those of you like me, when I was going to school, was busy hurriedly trying to take notes on everything that the presenters have to present, there will be an audio tape of today's presentation available off the SUMA website starting the third week, 16th, I believe, of February. So by all means, take notes for yourself and your community and your fellow council members who aren't here, for them back home. But the entire presentation, as all of our presentations in the education session, are recorded, and you'll have an opportunity to access the recordings starting the 16th, I believe, of February. So if you do have a question to ask, I would ask that you approach the microphone so that back home you can hear your question, and those of us who are interested in what you have to ask, and of course the answer, would like to hear what the question is too. So that's some more housekeeping information rules for you. Now, on the exiting of this building, in the event of an emergency, this building is equipped with alarms that will sound and strobe lights that will signal. The building alarm system has two stages. The first stage is a warning stage with intermittent ringing and strobe lights flashing. The second stage, which is the more important one that we need to act upon, is evacuation, and that's a continuous ring and strobe lights on all the time. So continuous ring, get the heck out, and pulsating means be prepared for evacuation. There are several exits. Those of us who have mobility challenges, TCU staff will be available to assist those of us who have some mobility issue to exit the building, and we're to exit the building and stay outside until advised to go back in to the building. Any questions on that? Has never happened in the number of years that I've been in this facility, but it always could. Therefore, AKA insurance, right? Right. So it's a pleasure again to have you all here, and we'll get on to the order of business. And our title today is called A Lifeline When Things Go Wrong insurance claims management. This is sponsored, as I said, by SUMA Assure, and as most of you know, SUMA Assure is a liability and property insurer owned by towns, villages, cities, resort villages in the province. In other words, it's a company owned by its subscribers who are municipalities. One of SUMA Assure's goals is to share information between members on risk management rather than operating in a silo as we previously have done. With 182, my script says, but as of January 31st, 183 towns, villages, cities, and resort villages are subscribers to the SUMA Assure program. The program as of today is encouraging us to share information which is vital to preventing losses and managing municipal risk. It's not our money, it's not my money, it's the community's money. That's why we put on events such as this one today. SUMA Assure's philosophy is not just to collect insurance premiums and pay claims, but rather to attempt to prevent the losses before they occur. For today's session, we have two of our close family members who are very familiar with SUMA Assure and managing insurance claims. And the first one I'd like to introduce is Jason Minville. Jason is the Vice President of Public Sector and Financial Institutions at Aon Reed Stenhouse in Regina, and Aon is the attorney in fact for the SUMA Assure Insurance Reciprocal. Jason is the account manager for most of SUMA Assure's subscribing municipalities, certainly in the southern part of Saskatchewan, and has managed the reciprocal risk control program which began in 2012. Next to Jason is Vince Marino, and Vince is the Vice President and Team Lead for Claims for Aon Reed Stenhouse, and he's based in Edmonton. Vince is also the Claims Administrator for the SUMA Assure Reciprocal Program. His experience working with various insurers and as an independent adjuster have given him the depth of knowledge to analyze, evaluate, and effectively manage reciprocal claims. The third member of our family, a cousin, is Nicholas Can. Nicholas is a partner in the McKercher Law Firm Regina office. His practice includes insurance defense, professional liability defense, and commercial litigation. Nicholas also has a significant amount of experience in both administrative and privacy law. Fellow delegates, ladies and gentlemen, please welcome our panel, and we'll turn it over to Jason. Thank you.
Thanks, Dad.
You're welcome, son.
Welcome, everyone. Thanks for coming. We're going to be talking about claims management today. We're going to be speaking in very general terms. We know that not everyone in the room is a subscriber to SUMA Assure, so we're not going to be specific to the reciprocal itself. We're also going to concentrate mainly on property and general liability claims, which makes up the bulk of our work. There's a number of other claims type issues that we deal with, crime claims, errors and omissions, whatnot. We don't deal with that specifically in the presentation, but we do welcome any questions at the end, your what ifs, your how comes, your theoretical questions at the end. I'll be happy to answer any claims related questions that you have. That's our agenda for today. You can see there's a test at the end there, so we'll see how you all do. Now, as Barry mentioned, our philosophy and what any insurance company likes is the ability for one of their insureds is to prevent losses before they occur and not just call them when things go wrong. So while this session is about claims, it's not about risk management. We did want to put some of the main things that we use that kind of backstop the program. Contractor management, transferring your risk to via contract, emergency response plans, how you investigate accidents, and maybe even more importantly, incidents before they turn into accidents, which turn into insurance claims. And training, hazard assessment. These are just the things that we try to train our SUMA Assure members in and try to assist them in is, like Barry said, preventing losses before they occur. Unfortunately, the losses do occur, and that's when you turn to your claims people, and that's what this session is about, is how to manage those claims when they happen. Before we go into the claims management, we're just going to give kind of an insurance 101 session. And we do this with not just our municipal clients, but with all clients. And really there are only four main types of insurance. You've got your property insurance, so your first party insurance, you're insuring your own building and contents, etc., what you have on your statement of values. So if you picture your property insurance, that's protecting you for what happens to you and what happens to your stuff. General liability insurance, third party liability, that's what you've done to other people, things you can get sued for by other people. Professional liability is one of the other four main areas of insurance, and that's for professional advice. So your doctors, your lawyers, your insurance brokers, and engineers, architects. The last one that's one of the main ones is construction and project insurance. So you have your course of construction insurance, builder's risk, bonding, that type of thing, all your surety goods for the projects that are underway and aren't yet on your statement of values. All the other types of insurance you hear about, from network, cyber liability insurance, environmental insurance, they all come out as a result of the exclusions that are contained within one of those four main policies. So some of the things that are common exclusions, of course, you've got drugs, cash, proceeds of crime. Furs, believe it or not, are typically excluded. They have special furriers policies. Automobiles are excluded, of course, because they'll be under your plates, with the exception of non-owned automobiles. So if you're renting or leasing an automobile, typically that will be covered off under your general liability policy on what's called a non-owned auto endorsement. So that's for vehicles that you're renting or leasing for 30 days or less. Other typical exclusions: wear and tear, fraud, criminal activity, and vermin and infestation. Pollution, of course, and then we've got mold on there too. Now, mold is excluded under most insurance policies, with the exception of if it's a result of a covered peril. So if something else that was covered on your insurance policy causes the mold, then typically an insurance policy should respond in that case. And these two here, war and nuclear powers. Now, these ones are always excluded on all policies, and this is because they're considered uninsurable risks. Anyone guess what this one would be for, these exclusions? It would be design and defect and workmanship. So liability insurance. Now this is one where we get a lot of questions, a lot of what ifs. People call us up and they say, what if the light in the arena falls and whatnot, and they'll come up with all kinds of scenarios. It's kind of a stump the broker kind of game that you play with the people that phone you. And what I like to try to give them is, instead of just dealing with the direct question, is this covered, is I try to get them trained into seeing these four items. And this is what it takes for your liability. These things have to be in place for your liability insurance policy to respond. So you must be legally liable for what happened, and that's negligent. And Nicholas is going to speak later about negligence and gross negligence. It can't be excluded. It can't be one of those exclusions on the policy, so typical or covered under another insurance policy. So your automobile policy or workers' compensation board type claim, obviously those would be handled through a different form of insurance. The circumstance of the claim, it can't be unexpected. Must be unexpected or unintended. So you can't go in and burn the town hall down and try to collect insurance. And you have to be sued for monetary damages, so you have to be sued for money. And that means if somebody sues you and says, we want you to keep the noise down or move the parade route or things like that, that's not something that would typically trigger your liability policy. Next thing I want to talk about are warranties that are on some insurance policies, some number of municipal policies. And these are pitfalls. In the next few slides, I'm just going to show some of these are, they're like hidden time bombs in your insurance policy. And so when you all go back, you should take a look to see if any of these are included. Now this one here is what's called a certified water treatment plant operator warranty. So when you first look at it, it looks kind of benign, but then when you see where it talks about the certification that's required, they have to be certified with water regulations 2002, et cetera, et cetera. So that's a certain standard. They have to meet that standard. So if you take that literally, if you have somebody that exceeds that standard and is more qualified than the person that has that standard, if you took the policy literally, you could be in for a denial. So what they've done in response is this other clause. If you can't get your broker to get rid of the certified water treatment plant operator warranty completely, then you should at least get them to amend it to include that second clause, which is, to have that certification or higher. The pest control exclusion, and there's also on a number of policies a pest control officer warranty on there, and so you can basically see anything that's related to pest control could be excluded under your policy. And the reason I have a picture of Pepe Le Pew there is because we had a claim in Alberta where a pest control officer came in and shot a skunk that was in town, and he only wounded the skunk, and so the skunk ended up running away and crawling under the local grocery store and died, and when he died he did his skunk thing and sprayed his stuff and contaminated about $300,000 worth of food in the store. So if you had that exclusion on the policy, that wouldn't have been covered under your insurance policy. And the last one there is, I've only seen once, and I can't stress enough that you should go back and check your policy to see if it's on there. It's not on the SUMA policy, but you should check anyways, just as you're part of your due diligence. But the bodily injury or property damage arising out of any actual or alleged error, misstatement, misleading statement, act or omission or neglect or breach of duty by the insured or by any other person whose acts the insured is legally responsible arising out of the discharge of duties as a municipality and or municipal council or as duly elected or appointed members or officials thereof. If you took that literally, you could really use that to deny any claim, because you could tie that back to any council or any employee of the municipality. I'm going to hand over to Nick. He's going to talk about negligence here.
Fascinating topic for everyone, I'm sure. Well, thank you for having me, of course. I hope that we never meet. So the Blythe v. Birmingham case, and I don't want to get into the fine points of all that, but basically I think it's a good illustration of what negligence is, or can you hear me? Hello? How's that? Okay. In that case, they installed a fire hydrant in Birmingham, England, a long time ago. They installed the fire hydrant. There's a severe frost that winter, which is usual here. It is not there. It ruptures. There's a leak into the guy's basement. He sues the waterworks. Well, the court came back and said, well, they couldn't possibly have expected a severe frost. It's unusual. So sorry, guy with all the damage. The city is, the waterworks is not on the hook for it. And that's really what it comes down to is this something that could be expected to have happened? In Saskatchewan, you have to watch out for things like frost. Obviously, that is going to happen. So, govern yourselves accordingly, as they say. As far as what negligence is, it's very fact sensitive. It depends on the circumstances, depends on what happened. It depends on who the parties are. We all owe everyone else. There's a standard of care. It's the level of how much care you have to pay someone, and. For example, you have to take more care with people that are paying admission to come into the hockey arena than you do for the person who is trespassing. It's a sliding scale, and it changes every time, basically. Anyway. So gross negligence, and this is one of the ones that, so how many people here had a slip and fall claim against your municipality? Yeah. And that's one of the things, that's sort of the basics in Saskatchewan or any of the prairie or the cold provinces, which I guess is most of them, but for BC. Gross negligence, it's one of those things where I can't define it, but I know it when I see it. Like a couple of other things have been described that way. It's basically, you're so far under the expected level of care that it's basically reckless. It's almost when the conduct is almost deliberate. It's not, whoops, we forgot to throw out salt yesterday morning. It's, we don't care if people slip and fall in this place, and our actions demonstrate that. Again, there is not a specific definition of what gross negligence is. Under the legislation that covers municipalities for slip and falls, for slipping on ice and snow, what has to be demonstrated is that gross negligence. And it can be a difficult thing for someone who's suing you to prove. They really have to show that nothing was done.
So subrogation, another fascinating term under the insurance policy. And basically what it is, and I'll just read it directly from the slide here, is right for the insurer to pursue a third party that caused an insurance loss to the insured. This is done as a means of recovering the amount of the claim paid to the insured for the loss. So essentially, when the insurance company pays for a loss, and that loss is as a result of someone's action, someone did something wrong, caused damages to your property or what have you, the insurance company is able to recover that amount that has been paid for that loss against the person or the entity that committed the wrong, essentially, and that's the insurance term of subrogation. It could be as easy as a motor vehicle accident, somebody rear-ending you or turning in left in front of you, where your insurance company would recover the damages paid to your own insurer, or caused to your vehicle, sorry. As complex as litigation when it comes to design defects that may have caused a loss within your building or what have you. And in Saskatchewan and also in Alberta, of course, it's always done in the name of the insured. So if there's an action or a statement of claim that's issued, you will always see that it's done in the name of the policyholder or the insured.
So we're just going to take a little break here and play a game called Guess the Policy, because this is one that we get a lot, and it's sometimes I think some of our municipalities have difficulty understanding how insurance works and why certain policies respond. So in this case here, we've got a town employee mowing grass on a boulevard, shoots a rock through the window of a local resident's home. So show of hands here, who thinks that the town's insurance policy would respond in this case? Okay, and a show of hands, who thinks the homeowner's policy would respond? Okay, well, the homeowner's policy would respond because they've paid premium for a property insurance policy for first-party coverage from their insurance company. So what the insurance company would do is they would typically pay subject to a deductible and subject to the policy wordings. And if they felt that the town, the person driving the mower, was negligent, then they would send a demand letter to the town saying, we've paid out a certain amount of money to fix this window at our resident's home. We think you are responsible, and we're coming after you for the money. That's what we need to trigger the liability policy. So that's when we were talking, that's what I was speaking about earlier, where you have to be legally liable and you have to have a written demand for monetary damages. That's what would trigger the liability policy. So it should be pretty basic now. You turn you turn it over and you say, okay, a homeowner's mowing grass and he shoots a rock through the window of the town office. Which insurance policy would respond? Well, in this case, if it was a SUMA policy, SUMA would respond and we would pay the property damage, and then we would send a demand letter to the homeowner saying, you were mowing, you were negligent, we feel, and we're going to come after you for the money. So that's how it works, and that's that subrogation that Vince was referring to earlier. Take a little minute here to talk about the Municipalities Act, Nick.
Yeah, certainly. Municipalities Act, it's the piece of legislation that governs what municipalities do. It's very long and fascinating, as you can imagine. But it's a very good thing to be familiar with and be aware of, at least sort of some of the main points of it. Section 339 that's up here, what that basically says is a municipality isn't liable, which means they're not responsible for any damage that occurs if they're acting in accordance with the Act, unless it's a negligence claim. So if you're a municipality, you're doing things as the Act says you do, you can't be successfully sued. Anyone can sue anyone. We could walk out of this room and someone could run down to the courthouse and file a statement of claim against me right now. But whether you're successful at the end is a whole different story. The exception to that is, as it says there, unless it is a negligence or a tort action. And Jason has a very clever slide about torts. I like torts, but that's not where I work anyway. Basically, a tort, it's a civil action, which means it's not criminal, right? There's no threat of jail time. It's a civil action, and it's when most people think of a lawsuit, it's that. That's what it is. It's on TV. If there's a lawsuit, that's the thing that it is. Someone got hurt or property got damaged. Usually negligence is involved, and again, that's did the person who caused the damage, did they do what they were supposed to have done to prevent it from happening? Intent is usually not required. That means you don't have to have meant to do it, which is in criminal law, of course. You have to actually mean to have done whatever the bad thing was. There's a couple of exceptions to that. One of them is defamation, and I've certainly been involved in claims for defamation on behalf of insurers. I don't know about what your policy is, but they are out there. If someone from the town says or writes something very nasty about somebody, that is a place where you can be sued. Okay, that one's going good. Nope.
I'll go back to...
Of course, I'd have to wonder whether if the person did it on purpose. Anyway, so snow on sidewalks, and this is one of the most common ones, and it's a good example of something to be aware of. Limitation period. What that means is that in order to sue someone in this country and, well, let's call it most countries, you have to do it within a certain period of time. And if you don't, you're out of luck in a lot of circumstances. If you are going to sue a municipality, or you plan to, you have to notify the municipality that you were hurt if you slip on sidewalks, crosswalks, extensions of sidewalks. If you slip on ice and snow or slush, you have to notify them within 30 days of it happening. It's a pretty tight timeline. Just for example, for other types of lawsuits, you got 2 years from the date of when it happens to sue someone. So this is 30 days, that's a month, that's pretty quick. If someone doesn't notify a municipality that they're going to sue them, and they do it even 31 days later, the defense that I would make on your behalf would be, sorry, you missed the time period. You didn't notify us, therefore you can't bring an action. You're barred, is as the phrase goes. The exception is as it says there, if the plaintiff is the person who does the suing, the defendant is the person who is getting sued. If the plaintiff can show that there was a reasonable excuse for it. I was in a coma for 3 months, for example. No, comas aren't funny, but in this case, you know.
I was going to say, I was on holidays for a week.
Well, no, holidays doesn't count. Comas would. And then the other part is, and the municipality isn't prejudiced by the lack of notice. Prejudice in the legal context is harm or injury, as in, did us not getting notified within 30 days, is that going to make it harder for us to defend this claim? Is there something that perhaps we could have done within that 30-day period that would have allowed us to gather the information and mount a defense? One of the biggest ones is witness recollection. You've got the slip and fall example. You've got your staff out there, your maintenance people doing whatever it is they do. Well, Larry or Susie is not going to remember what they did on Tuesday 3 months later. They're just not going to. We'll come to sweep and maintenance logs in a bit. That's one of the main reasons for it.
Actually, I'd maybe make a comment about documentation in that. We spoke about that in that slide. How important is documentation to defending a snow on sidewalk claim for you?
It's absolutely crucial, and it's the only...
On the previous slide at the bottom, there's something about barring the action is not barred in the case of death.
Yes.
Exactly is that.
That means if the person is injured and dies as a result, they're not bound by the 30-day notice period because...
So there is state can bring an action at any time after?
Correct.
Is there a time limit on that?
1 year. Yeah. Yeah, with documentation, this is the only thing that I'm going to finger wag about, and this is making my life easier. For ice and snow maintenance, please, 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 written policies on ice and snow maintenance, what's done during the months when we have to worry about it, a priority map showing, okay, here are the streets, here's the priority in which they're cleared, and then the most important thing, and this is if we ever do have to meet, and again, I hope we don't, the very first question I'm going to ask you, if it's a slip and fall claim, is please send me all of your maintenance logs. Mm-hmm. And what I'm looking for, and this is crucial, what I'm looking for to make me the happiest boy on earth is if there is documentation from January 12th, 2000 whatever, that shows that on that day, Larry and Susie cleared Main Street at 11 a.m., they put down salt, and that's what they did. And I'm going to be asking you for the logs of that day, a month before and a month afterward to show it's consistent. I've got there's something going on right now where we've got the sweet blogs, which show what Larry and Susie did, but not the time. And I've got the other lawyer saying, well, you can't establish that this stuff was done before the person fell. Now, as it happens, you don't have to show that. It's reasonable if you did it that day. But, you know, that's the thing. I want to be able to say, oh, yeah, here, look at this. This is reasonable. This establishes what we do is reasonable in terms of maintaining ice and snow, because you can't stop it. It's always going to happen. It's that documentation. Those are the things that I like to surround myself with and make myself all comfy, cozy with. And that can get rid of a claim for you, just like that.
Streets.
Streets and roads. Yeah. So this one, got a that example. This one is you're going to get all sorts of arguing about what this means in terms of the lawyers, because it's our job, right? If it wasn't, I would have very little to do. A municipality isn't responsible for the presence or absence of, well, the things that are listed there, walls, fence, etc. Or if you've got any obstruction, earth, tree, rock, or anything else along a street or a road that is not on the traveled portion of the road, as in it's not in the roadway, I guess would be the simplest way to describe that.
Yeah, and I think there's one part that maybe I didn't include in here where it takes into consideration the character and nature of the road. There was some verbiage to that effect. So if you've got a heritage neighborhood and you have a pothole, that can be expected, versus, the example you were talking last night, Vince, about, a big pothole in the middle of the Trans-Canada Highway. They're two very different things. The other thing that the Act considers is if there's hundreds of people traveling on that road and one person hits that pothole, that's taken into consideration. If there's more and more people hitting that, and it's obviously a more serious problem. If you're just the only person that hit it, it puts you in a difficult position from the point of view of being a plaintiff and being successful. Trees, this is the one where we use for trees a lot, where branches blow onto cars. We had one where a ratepayer asked the town to prune some limbs. The town unfortunately had bigger things to deal with. They had a big PDAP flood that year, and so it was kind of, as far as priority goes, the tree pruning was kind of went down their list of things to do. And then to make matters worse, there was 85-kilometer-an-hour winds one night, and the branch blew and landed on the ratepayer's vehicle. And so she thought, well, I've already informed the town, to take care of this. And this is where this 345A will come in to effect, or 339, where the municipality isn't liable for not having done the thing if they did it in good faith. So if they had a reason to not do it, time, budget, you name it. And in that case, it was interesting too, because despite knowing the problem, informing the town, she still parked there. But the town wanted to pay the deductible. There's a $700 deductible involved, and we always counsel against that, because it's a real slippery slope when you pay it for one ratepayer, and then 2 months later you have a plow wind come through town, and now you've got 100 vehicles have damage. Then you've set a real nasty precedent, and it could prejudice your position. Now, in the case of the same as the example with the lawnmower, that person has auto insurance, and that's the insurance. They've bought that insurance for the physical damage to their automobile, and that's the policy that should respond. The fact that they have $0 deductible, $1,000 deductible, whatever it is, that's the decision they make when they purchase insurance. So I encourage you not to be overly sympathetic with them in the case of the deductible. Did you want to talk about
sewer backups. And this one, the wording of this section is not immediately clear. I had to read it a couple of times. Like, wait, what are they saying here? So I guess the first thing, this section provides immunity for municipalities in certain cases for sewer backups. And the important word is in the first line there, nuisance. Nuisance is a legal concept, and to me, I call it the monster rule. And what it means is I'm allowed to have monsters in my backyard, but if one of those monsters gets free and terrorizes the countryside, I have to pay for any of the damage that the monster decided to do. The most common example would be you've got a fire in the backyard, you're doing crop burning, or et cetera, et cetera. It gets loose, burns down the neighbor's place, nuisance. It's essentially strict liability, which means it doesn't matter if you were negligent or anything like that. If it happened, you pay. You pay now. So what this is saying is that a nuisance action is often with water damage. Pipe bursts, it spreads into my basement. The claim would try to be nuisance, as in, hey, it doesn't matter if you guys were negligent or not. Water was in my basement, I caused damage. What this section says is you cannot sue a municipality, or at least they're not responsible. As I said, you can always sue them. They're not going to be responsible if someone is just suing for the simple fact that water got into their basement. I'm just using that as the easiest example. You have to find or prove that the municipality was in somehow, well, they did it on purpose, which doesn't happen very often, or they were negligent. Other people are responsible for nuisance, municipalities are not. This is a nice little protection that municipalities get.
Yeah, and it was probably our number one source of demand letters that we were receiving from other insurance companies, and they seem to be down to a trickle now. I think, I don't know, maybe they see SUMA, they don't bother anymore. But I think in the years since the reciprocal's been running, I think there's been one or two that have, maybe reached the standard of gross negligence that, we felt for one reason or another to settle or pay or we lost. So,
Just to expand on that a little bit, the documentation is also important, just like Nicholas was talking about in terms of slip and falls and maintenance records. Keeping your records of when the lines were cleaned, steamed, or what have you is very important. If a sewer backup were to occur in a ratepayer's home, it's important to know when those lines were last cleaned or steamed. If it's a pipe broke or anything like that, the Municipality Act does protect us. But if it's just a blockage in the line, it happens. But if we can show that we've cleaned the line on a regular basis, every year at the same time of year, we can show that we've been following a reasonable methodology when it comes to maintaining the lines.
and if you, for those that aren't with SUMA, if you do have a sewer backup claim that's you're being subrogated against by another insurance company, I would strongly suggest that you really look into if it's being paid, just to see who's insuring the homeowner too, and because if you've got the same company insuring the homeowner that's insuring the town, there could be kind of a conflict of interest there that you should be on the lookout for. Now, time limitations, Nicholas had already spoken about that. Typically in Saskatchewan, the statute is 2 years, as he mentioned. With municipalities, that does drop to 1 year, and then for snow on sidewalks, et cetera, it drops to 30 days. But the exception he gave, with the person being in a coma, mental incapacitation can be, something that can extend the tail on that timeline, and I believe minors as well. It would be, I believe, 1 year from the date that they're from the age of majority. So if you have a slip and fall on a sidewalk and it's a 3-year-old, that could have a 16-year tail on it when you add the 15 years till they're 18 and then throw the year that the statute has on top of that. So liability claims in general have a long tail, but especially long if it involves a minor.
Yeah, so legal precedence. What that means is, has it happened before? Simple as that. Is there a precedent for it? And a lot of the time what we're going to look at is the case law. We have a system of courts and judges and juries, and they hear cases relatively infrequently these days, but they still do. If there's a fact pattern, something happened, all right, here's the incident, let's call it. First thing that we're going to do, or one of the first things, is look at, okay, has the court ever considered this type of fact pattern before? Has a similar thing ever happened? If so, what did they do? If you do this in this circumstance, is a court going to find negligence? Or is a court going to say, no, there was no negligence here? And of course, as you can imagine, if we find a situation that looks similar, depending on which side of the dispute you're on, you're going to be trying to distinguish it, saying, well, it was close, but it's different because of this key point. It's just looking at the past. Okay, has this happened before? And what happened then?
This next slide here is a good example of how we'll defend one of our municipalities in case. In this case, it's the snow on sidewalks, and so it's a combination of citing the Municipalities Act and legal precedent that we'll use to defend the town. So you can see there, Section 342 of the Municipalities Act, that's your snow on sidewalks. And then we'll use case law. In this case, it was Metz v. Regina, 2006. It was a case, similar circumstances. There was ice and snow on the sidewalk, and the judge determined that, it's something that's, could be expected in Saskatchewan in winter, and so it was successfully defended. So it just goes to show you that's just, us doing our job to defend the town there. So anything to add?
I guess just the wording is unusual danger, and that's what municipalities and individuals have to watch out for. Is something an unusual danger? An unusual danger? It's pretty simple. Should this person have expected to find that thing where they found it? As in, if I find ice and snow on a sidewalk in January in Saskatchewan, is that unusual? No, it's not. You, as an adult, you are expected to take reasonable care for your own safety. You should have known it was going to be there. But there is not a blanket rule that says ice and snow claims in this province, you don't get to make them. If you slip on ice and snow, you don't get to make them. There isn't that. They're going to look at the individual circumstances of whatever the facts were to determine whether or not the municipality I was talking about here took the reasonable steps to prevent injury from ice and snow. So, I mean, the Metz case and a bunch of others that say the same type of thing, they are very, very helpful, but always remember you can still be successfully sued if someone slips on ice and snow and injures themselves in the right circumstances. So it's not a get out of jail free card.
Well, speaking of getting sued, we're on to, if all else fails, litigation and settlement, and this is where we turn to Nicholas for his advice.
Yeah, none of these things ever happen, by the way. not a single one. So just very quickly, I'll run through the basic process, because if you are fortunate enough to never have been sued or involved in litigation, you may not have any idea. I'll very quickly here. First thing that happens is the statement of claim. That's where the plaintiff makes all sorts of nasty allegations about you. The response is called the statement of defense, and it's you find out something happened, you contact your insurer contacts me or someone like me to represent you. I do a bunch of investigating and interviewing and ask, where are your sweep logs, send me your policies, where is all that good stuff, because obviously you all have them, right?
Sure.
Yeah. Especially Sun Valley.
Oh,
yeah.
What was that again? What do we have?
Yeah, exactly. I'll send you a note. And then the response to the statement of claim is the statement of defense. And it's basically what it comes down to is us saying, no. Didn't happen. We deny everything. After that, in this province, it's called mandatory mediation. And a representative of all the parties is required to attend. It's often a town administrator or a council member, someone who is in a position who can either has some kind of authority or is someone who can speak about whatever happened. Everyone has to go. It's off the record. You can't repeat anything that was said in it. It's an attempt to try to get the thing to resolve early on. There's different opinions in the legal community as to how successful it is. That's for another day. After mediation is document exchange. You're required to hand over all of your relevant documents, anything about the incident, whatever it happens to have been. After that is called questioning. It used to be called examinations for discovery, for those of you who may have been familiar with that. And it's where a representative of the municipality gets to sit in the hot seat and is questioned under oath, on the record, with a court reporter by the lawyer for the person who says that they were injured or had damage. I get to do the same thing to the plaintiff and ask them all sorts of questions. After that is what's called a pretrial conference. It's held at the courthouse. There is a judge there, but it's informal as anything can be with the judge sitting in the room, of course. Everyone prepares detailed briefs of fact and law, setting out why they are so right and why the other guy is so wrong, and the judge will give his or her opinion as to what they would do if this made it to trial. After that is the trial. Something like 2% of all actions make it to trial because it's, well, for a whole bunch of reasons. And just if you ever do get sued and you and I will be friends for 2 to 3 years, you should assume, if it's going to go all the way. It's a very long process. So, litigation. Oh, look, there's the first one. It's expensive and time-consuming. It just is. Yeah. Most claims, as we've been talking about, that get someone like me involved, it's property damage or bodily injury. Everyone, myself included, is going to ask, well, what did you do back then? What were your policies? What were your procedures? How can the plaintiff and their lawyer poke holes in the things that we did? This is where documentation is critical. That's how you can get rid of these things, or at least make it extremely difficult for someone to successfully come after you. Again, you get sued, you find out about a claim, call your insurer. I guess talk to whoever you need to within your municipality, but call your insurer. This is self-serving, I know. Don't try to deal with it yourself.
Yeah, I'll just make a point there. We have had some experiences where instead of calling us when you receive the statement of claim, we're getting a call after you've lost the case and they're wondering about insurance proceeds. So it's a little late for your insurer to come to the table after you've lost it yourself. So.
Yeah, well, we talked about the documentation in the context of a slip and fall. Apply that generally. You know, it's he or she who has the most paper wins. So was a duty of care owed? Duty of care is, what did you have to do? What were you required to do to prevent someone or something from getting damaged? Totally fact sensitive. Completely depends on who the parties are and the circumstances. You know, was this someone who I should have been keeping an eye out for? If I didn't do this thing, or if I did do this thing, is the person who got hurt, is it reasonable that they were the type of person who might get hurt by it? Generally speaking, is the person in your municipality? You should assume you owe some kind of duty to them in some way. Even criminals, even trespassers and people breaking into your house, so no man traps. Please don't, no punji sticks or those things that drop when you sit the tripwire. You cannot do any of that kind of stuff. Or I don't think, yeah, I know. Again, you got to make a phone call, right? Yeah. The standard of care, it really comes down to, can we prove that we took reasonable steps to address this risk? Reasonable. You talk to plaintiff's counsel, they will say you should have done everything under the sun in order to stop them happening, including wrapping everyone in your municipality in bubble wrap and guiding them around by hand all day. You know, it's probably a little bit less than that. You know, is there something reasonable we could have done to prevent this thing from happening? If there was and we didn't do it, why not? Is this a budgetary issue? Because that is also can be an effective defense for municipality. When one of these things comes in, I'll be looking at everything, doing an assessment, and then I'll provide my opinion on whether I think we're going to be able to prove that or show that, or at least give the plaintiff enough to worry about that they decide to pack up and go away. It's a gray area, because, again, I wouldn't have a job if it wasn't. And did you guys have any comments from the...
Nope.
That was good.
So, this is causation, because there's lots of times when something goes wrong, but that doesn't mean it's somebody else's fault, right? Things happen, they just do. A person has to prove that whatever you, I use the royal you, did or did not do actually caused or contributed to whatever the damage was. It's not enough for something to go wrong, it actually has to have caused it. There's a lot of situations where, yeah, you know what, more could have been done here. But this was going to happen in any event. That comes up a lot of times in the context of, for example, a medical claim. It may well be that the physician could have done something differently, but this thing was going to happen to them no matter what. There may have been negligence, but it didn't cause the damage to occur. What we're looking for there is, was there a break in the chain? Was there something that stepped in and went, oh, hang on, we're responsible for this. Maybe something went wrong over here, but if something else sort of got in there, another act, another omission by someone who was not connected to the municipality, of course, that actually made things worse or caused them to happen in the first place. Basically, is there something else on its own would have caused the damage? The value of the claim, and this is, as I've, the last point there, it's an art, it is not a science. There is no one is able to pinpoint to the penny what something is worth, even though we do it every single day. So, defendant was negligent, or likely is going to be found negligent. That action likely caused the plaintiff's damages. Okay, what's it worth? And that's the question, is what's it worth? A whole bunch of things go into this. It is a guess. It's an educated guess, is what I like to say. It's based on the facts. We're talking about what happened, the witnesses, the documents, the plaintiffs themselves. Who is this person? What kind of person are they? I had a situation where I walked out of a mediation and called up the insurer and said, we got a problem. I really like the plaintiff. She was just lovely, and everyone is going to believe everything she says. Look at the case law. Are there expert opinions involved? A lot of time you have to get an expert opinion to make a call or give their what they would have done, or whether they think the person is responsible for it. All of that sort of goes into whether or not, what the value is. With a personal injury claim, there's pain and suffering. You break your arm, that is worth a certain amount of money. Case law sets it out. Ballpark, about 40 grand. But we're going to look at the medical records. Was there anything else that might have contributed to it? You don't get the same, if you've previously broken your wrist and you break it again, you're not breaking a new wrist. There's already some wear and tear on that wrist, right? It's a used car and a new car. Are there any pre-existing conditions? Did this person have something medically that would have made the thing worse no matter what happened? Again, expert opinions. As a physiotherapist said, this is going to impact this person for the next 30 years. With out-of-pocket expenses, that's just receipts. I had to buy crutches and Band-Aids, and I had to travel to my chiropractor. Here are the receipts for that. You're entitled to be compensated for that. Future losses. This one it's crystal ball gazing. Something happened today. How's that going to affect someone in 25 years? Tough to calculate. A lot of times it's expert opinions. That's when claims can get very expensive, especially if you're talking about young people. Nobody wants to see anyone hurt, least of all young people, but it does happen. Where would this person have been but for this accident? And there's an odd correlation that every 10-year-old was about to get signed to the NFL, in the same way that flooded basements tend to have rare artwork stored in them. But it's a guess in a lot of cases. Property? Do you want to talk about property?
Well, we actually talk about it later. This was from the legal point of view, but we were going to talk about basis of settlement later, so.
Yeah, okay. Property damage claim, what's it worth? What's the extent of the damage? Are we going to be talking about replacement value, market value, actual cash value? Replacement value, how much is it going to cost to get this same thing? Market value, if I am a good faith seller, what's it going to be worth? eBay does not count. Actual cash value is exactly that. What's the actual cash value of the thing that was destroyed on the day it was destroyed, or damaged? Not everything is destroyed. Appraisals are often what are going to be used to substantiate that. Things to consider there are depreciation. Again, new car, used car. Brand new car is worth more than a used car. You don't get compensated, and this comes in with betterment is what it's called. You're not entitled to get something better than what you had. Again, using the car thing, if a 12-year-old car gets destroyed, you don't get the new model. That's just not how it works. Sometimes, of course, it's unavoidable. Do you have any comments on the damages or the valuation?
No, we're going to actually deal with valuation a little bit later under the property insurance
Okay.
section, so.
So settlement, and I'm flying through, as I said, a 2 to 3 year process in the space of about 15 minutes. Very few claims make it to trial, despite what you may see on TV and in the movies. Very few, very, very few, because it's expensive and it's time consuming for everybody. And it's risky. It's very risky. A settlement is not an admission that you did something wrong. A decision we made on settlement, it addresses the risk and the expense of trying to dispute it. Is there a risk that we're going to be on the hook for this thing at the end of the day? And how much is it going to cost for us to do that? If there's a real risk a plaintiff could receive $250,000 at the end of the day, they're willing to take $100,000 today. You can imagine there's going to be some very serious discussions between the lawyer and the insurance company and the insured as to whether or not that's something that we should be doing. My third bullet there was, I debated putting that in, but it's just a simple fact. An insured may often have little to no say on whether a claim is settled. It's just the reality. Some policies are different, but for the most part, it's a decision that's made at the end of the day by the person whose dime it is, and that's the insurer. It's not entered into willy-nilly. It's never done just because it's easier. A lot goes into it. It's a risk versus cost analysis. And my last point there, fighting on principle is really expensive, and there's only one person that wins. It's this guy right here. I tell clients, okay, we can do this, but fighting on principle, not advisable ever. There's always an asterisk. There's no ever, but for the most part, fighting on principle is not a good idea.
I did see an old adage one time, and it said, a lawsuit is a tree planted in a lawyer's garden.
Yeah. Well, that's exactly it. So do the stuff so I don't have to mow the lawn.
Pick the fruit.
Yeah, exactly. Yeah. Litigation doesn't happen in a vacuum. Other things to consider. It's publicity. Time away from work dealing with it, not just yours, but employees. If I'm bothering you with endless, inane-sounding questions and emails, the stress of dealing with it. And of course, we might lose. So that's the other thing, and that becomes public. A settlement, they're predictable because we control the process. The way that I describe it to our junior lawyers coming into the firm is, people go to lawyers when people can't sort out their problems. Lawyers go to judges when the lawyers can't sort out their problems. Judges and juries are unpredictable. You never know what they are going to do. We might have a slam dunk here. No such thing as a slam dunk. It does not exist, or at least I've never seen one. Judges and juries can find a way to help people, even if everything stacks up against them. Get that right person, the right circumstance, and that they'll bend to get that person what they want to. And something to keep in mind: settlements are confidential, and there's no admission of liability. In fact, it says explicitly in the documentation, we do not admit we are liable. We ain't responsible for this. Yeah, I know that can be cold comfort. Yeah. Well, and I mean, that's something that I've certainly talked about with people. It doesn't set a precedent because it's confidential. The precedent gets set when there's a judgment, when it goes to a trial. And, one of the things to consider is, do we want to set a precedent that this type of activity here might be negligence? Because if it is, if my case establishes that doing this, whatever this thing is negligent, that affects everybody. And I know that, I've certainly spoken to people, in your positions where they're like, well, if we give this person money, they're going to walk around town and tell everyone that we're easy pickings. And yeah, that is something to consider and keep in mind. But at the end of the day, the decision to resolve something, you might not have a direct say in it, but from my point of view, and I know working with Vince and Jason, it is only ever done with the best interest of the insured, which is you guys as the primary consideration. Yeah, people can talk about it. They're technically not allowed to talk about the amount, but they are allowed to say, yes, it was settled. So.
Now we talked about litigation, settlement, municipalities acts and such, but now we're going to talk about what actually happens when a claim or where a loss were to actually occur. Okay? So, heaven forbid there's a fire or sewer backup in the town office or what have you. What do you need to do? What happens next? Well, you need to mitigate the damage. You need to curtail the damage or so the building doesn't sustain more damage. In terms of a sewer backup, you have to clean up the water. You have to call a restoration company. In terms of a break and enter, if the door's busted down, you have to fix the door, you have to put a sheet of plywood up to protect the property from the elements or from other people getting into the premises. So again, protecting the persons and the property. We have contact information for all witnesses. Complete your incident report. Again, in terms of a slip and fall, are there any witnesses to that? In terms of a fire, any witnesses to anybody that was running out of the building? Were there any witnesses standing around the building at the time of the loss? The incident reports that I've seen coming from the various municipalities are completed, are done very well. It's always my job to get a few more details because I'm the one that makes the initial contact to the person reporting the claim. And again, once you have completed that incident report, report it to your broker. The broker submits it to me, the claims administrator, and at that point, an adjuster is assigned. So once the claim has been reported to your broker and it gets into my hands, the claims administrator, what do I do with it? Well, again, making first contact with yourself, finding out what exactly happened. Do we need, again, to mitigate the damage? Do we need to send out a restoration crew? Or do you have your own crews that can go in to clean up the water or board up the windows or fix the door? We always get into that process. From there, we review the policy to determine the coverage, the limits that you have on the building and on your contents, and discuss the deductible amounts that you have on the policy. And at that point, we set the reserves. And what are reserves is basically we set aside some funds over here to pay for the damages that have been sustained to your building or to pay for the loss. And that could fluctuate depending on the extent of damages. And then an adjuster, like I said earlier, is assigned. Now again, depending on the type of loss, we may have to assign an expert, whether that be an engineer, in terms of a business interruption loss, maybe a forensic accountant or what have you. If there is, in terms of a water damage loss, if the building is older, there's asbestos, or there could be an issue as asbestos, maybe an expert needs to be assigned to determine whether or not that needs to be tested so that we can, again, protect everybody that's working in the building. So once the adjuster has been assigned, it's the adjuster's duties to investigate, negotiate, and settle the claim. Now, in terms of negotiating and settle the claim, those are based on instructions that come from myself, from the account manager, and also from Nicholas here when the time comes. Another one of my duties is managing the reciprocal, the funds within the reciprocal, and setting aside the reserves, and again, issuing payments.
Now, this is a picture we have from a bulletin that SUMA came out with a few years ago, and yeah, now is not the time to wonder if you value your facility correctly. So we do stress to our towns and villages to correctly value the facilities and pick the appropriate basis of settlement. We typically suggest that people get a third-party appraisal done on the facility and rely on that. When you're arriving at the value of the facility, you have to bear in mind buildings and contents. So the buildings, of course, are your fixed structure, and the contents is what's inside. So when people are asking me, they're having trouble trying to determine what's building, what's contents, I just pretty much tell them to picture a big monster coming in and picking up the building, tearing it out of the ground and giving it a shake. Whatever falls out is contents, and whatever is left is the building. That's pretty much the easiest way to determine it. The various bases of settlement that are available in various property policies: replacement cost, replacing, repairing, constructing, whichever is the least amount, the same property on another site, without deduction for depreciation. Actual cash value, similar to the example that Vince and Nicholas were giving earlier with the cars. Actual cash value is, yes, what it's worth. So that is the value of the item or the facility less depreciation. For those that do get appraisals done, the terms that they use are CRN, so cost replacement new. That's appraisal speak for replacement cost. And then CRNLD, that's cost replacement new less depreciation. And so when we get those appraisal reports, we basically just take their acronyms and change it to RC or ACV. functional replacement cost is not available in all policies. It is something that SUMA offers, and that's replacing the structure not with what you had, but rather with what you would want in the event of a loss. So situations where this is very useful is in the case there you see the gargoyle sticking out of the old heritage building. It's not going to make a lot of financial sense for you to insure an old ornate structure to replacement cost. It's just going to be unreasonably expensive to replicate the same structure. The other case is not only just heritage structures, but sometimes with size. If your demographic has changed and your town, used to have a population of 600 and now you're down to 200, you might be able to insure for a smaller facility. Same with like rinks. If you had a 600-seat arena and now you need a 200-seat arena, you can insure for that rather than with the size of what you had. And conversely, you can do the opposite under the policy. You can, if you're lucky enough to be one of the towns that's growing and you've gone from 200 to 600, you can insure to a higher value than what you actually have. Guaranteed replacement cost is a popular one. It's not offered on a lot of facilities, but it's the cost of replacing basically exactly what you had regardless of what you had it insured for. Now there's a couple of drawbacks to it. One of them is that you rely on the insurer to determine that value for you. So if they tell you that the facility is a $6 million structure and it burns to the ground and they only spent $4 million to replace the exact structure, then you've been potentially wasting your premium dollars on that.
So co-insurance. In some policies, on the declaration page, that's the page that outlines the coverage, there may be a clause in bold or in red letters that may say that there is a clause within this policy that may limit the amount payable. And at times that's talking about the co-insurance clause. And basically what that means is that you must insure the property to its value. If it's not insured to its value, you may become a co-insurer, or you may you may share in the loss. So in the next slide here, Jason has put together some examples here of the co-insurance clause and how it's applied. So if you'd like to follow along here, the first example we have, the insurance carried is $600,000. The claim submitted is $300,000. So it's a simple formula really that's being used. It's the amount of insurance that you did have over the amount of insurance that you should have had, multiply that by the loss. So it's a fraction or percentage, multiply that by the loss. So in the first example, the policyholder did have $600,000 worth of insurance. He should have had $1 million because the building was evaluated at $1 million. And the co-insurance percentage or the co-insurance clause stated that you must be insured to 90% of its value. So really you should have $900,000 worth of insurance on that building. The loss, as you can see, is $300,000. You follow the formula, did over should times the loss, and the insurance company pays $200,000 of your $300,000 loss. So you're basically insured or underinsured by a third. So again, in this example, the insurance company would pay $200,000 and the policyholder would pay the remaining $100,000 subject to the deductible. Clear as mud, right? Example 2. The insurance carried again is $900,000 here, and the claim submitted is $300,000. Again, following the formula, the amount of insurance carried, or what he did have, or what the policyholder did have, was $900,000. He should have had $1 million, but the co-insurance clause says 90%. So really it should be $900,000. That's the minimum amount of insurance that he should have had. And again, the loss is $300,000. Follow along the formula, did over should times the loss. The policyholder gets 100% of the loss because he insured to at least 90% of the value. And again, subject to the deductible. Yes, sir.
This stuff doesn't come up until later.
who are we supposed to rely on to ensure that we have proper insurance? Are you saying that it's okay to be screwed in the left ear because the broker doesn't bother to tell us any of this stuff? Or should we rely on our administrator to be able to tell us this kind of information? I'm just curious. These examples would drive me crazy if it happened to us. And if you guys insuring us, if you didn't bother to tell us that it was there. Because earlier there was a comment about trick clauses in your insurance policy. How are we supposed to recognize trick policy terms? That's what we hired you guys for, or our own local broker, whoever it is. And I'm just curious what you would say to us. So we should rely on to make sure we've got proper insurance.
Yeah, you do have to rely on the broker, and I will say it almost seems like a planted question for us because under the SUMA policy, we have no co-insurance clause, and the point I was trying to make earlier is that we're trying to cover not just the SUMA subscribers, but everyone in the room. None of those clauses are in any of the SUMA policies, the ones that I showed earlier, and we don't have a co-insurance clause in our policy. But yes, you do rely on the broker for their knowledge to some extent, but when it comes to setting values, that is the municipality's responsibility to determine the values. We can't set the values and tell you what your buildings are worth, and that's where what we do. Yeah.
We've been through all that. We have somebody come in once a year or every second year and evaluates everything in our community.
Yeah.
We have that done, but I'm just worried about clauses like that, right? So fine, sure it doesn't happen. But you're saying that there would be brokers out there that would do this, and there would be no concern in their part that they might be doing this.
Well, it's unfortunately true. Yes, there are some brokers that don't have the knowledge of they get the policy from their insurance company and maybe haven't done a thorough review to look at the pitfalls of it. And those clauses that were up there are they're not something theoretical that I pulled off the internet. They're out of policies that exist in the province here.
I might be the only person in this whole room that's worried about that kind of thing. Just wanted to ask. When I go back and I talk to my administrator, I'll have a better idea of what I'm talking about in terms of what we have to do to protect this. I've never seen the policy that the city has. Ever.
Yeah.
What do I get some sort of response? Thank you.
It's important, at least once a year on renewal to review your policy, to make sure that the values are there. Like you said, you have somebody coming in once a year or what have you. But it is important to review the policy thoroughly with your broker, whoever that might be, account manager, whatever the case may be, to understand these particular types of clauses. Now, again, SUMA sure does not have this particular clause in the policy, but for this purpose, this is why it was outlined.
And one of the things that's, I think, valuable for us is that, we do have 183 cities, towns, and villages, and so we deal with nothing but municipalities. Now, while we're insurance brokers, and that's part of one of our duties as attorney-in-fact for the reciprocal, we kind of wear a different hat than your typical broker-client relationship, because as attorney-in-fact, we wouldn't be doing a good job for our members if we were denying claims and pulling fast ones. If anything, we're a little more onerous on trying to get claims paid. It's you're our owners, and if we're not doing a good job in providing as broad of a coverage as we can economically to the group, then we wouldn't be doing our job. At the same time, like any insurance policy, there are you can't just pay everything and be irresponsible. There are policy provisions and exclusions and whatnot. We have fewer than them, but that's because we are dedicated 100% to only municipalities, and so we don't act surprised when a municipality acts like a municipality. We're not requiring you to report that you're having a parade or fireworks because there's a little clause in there, and we can say, aha, you didn't tell us about the parade. That's not something we do. So.
Can you carry on, or are you done?
Yeah, no, we've got a couple more pages left.
Just one more example here, the last one,
Oh, sorry.
where the... Sorry?
Then we'll do questions.
Okay, So the last example here where, again, the insurance carried is 900 grand, the loss is $1 million is the total loss in this example. The formula is not applied because the limit of insurance would apply in this case here of 900 grand. So the next slide, salvage, another interesting insurance term. The best example is if an insurance policy is going to pay for the replacement of a particular item, a piece of equipment, and you go out and replace that piece of equipment. The damaged piece of equipment now belongs to the insurance company called salvage. So the insurance company can do whatever they wish with that piece of equipment. They can sell it, and they can apply those funds recovered to the overall claim. There are certain opportunities where if you want the piece of salvage, some insurers may say you can buy it back, or that amount can be deducted from the overall settlement.
And I know we're running out of time here, so I'm just going to touch on PDAP claims because we do deal with a lot of them. And this is strangely one of the few times where you actually do typically want your insurance company to deny the insurance claim. Now, floods, flooding is the typical PDAP type claim that comes across our desk, and we have quite a few of them every year, unfortunately. Now, up there is a process for municipal claimants, but I'll just talk about what you have to deal with your broker, and that is, in order to access PDAP, you do need a denial of insurance coverage from your insurance company, and that's a difficult one because we do have flood coverage in the policy, there is coverage, and so it's difficult to deny it when there is coverage. But where we kind of come into play is because flood typically has a high deductible, $25,000, $50,000, $100,000. And the reason that is because when a flood comes, it's not usually going to hit one town, and then if it hits a town, it's not going to hit one building, and so that's why they have the high deductibles for flooding. So when we get the request, we've been very successful with our municipalities in denying it based on the deductible, but we use that language. The coverage is denied because it doesn't meet your deductible. The other thing with PDAP is that it does allow you to access some insurance that you wouldn't be covered for under your property policy. So under your insurance policy, you're typically going to list all your buildings, but you're not going to have on your statement of values your roads, your infrastructure, things like this. And PDAP will cover for those types of losses and notification and bottled water. And so there are a number of benefits to being able to access PDAP, and that's where you have to work with your broker to get that denial and to have it worded correctly. We have seen in some towns where we've been successful, but we've counseled some other towns that were denied just on the basis of how the letter was worded, and so we counseled them and then helped their broker, word it correctly, and they were managed to access PDAP just by interchanging a few words on the policy or on the letter. So that concludes our presentation. If there are any questions, please head to the mic.
Yes, hello. Rob Mardell, Mayor of the Town of Choiceland. We've got a scenario, and I'm sure it's probably happened in other communities. During the spring of the year, with the freeze-thaw, the odd time we have culverts that get blocked, either with debris or ice. And last year we took our fire truck out and flushed these culverts to prevent flooding and damage to property, personal property. But is that unregistered vehicle covered in the case of an accident or causing an accident when it's not really doing or performing the duty that it was insured for?
Yeah, it's an interesting one. We come across it a lot. The way the Highway Traffic Safety Act reads is that it says the fire vehicle, in order to be unregistered, unplated, it has to be responding to a fire. It doesn't even say an emergency. The way the Act reads, it reads fire. Now, there's been some opinions from SGI and the Office of Fire Commissioner, and they now encompass emergency. They believe that was the intent of the Act, and so that's where they're going. So we're the only jurisdiction in the world that doesn't require plating of fire vehicles, and so it's unique to Saskatchewan. In the case where you're going to use it to, I'm not sure if the term was blowout culverts, you would need to plate that vehicle. The other cases where you would need to plate it is if you have a mutual aid agreement with, if you're on a border and you have a mutual aid agreement with Alberta or Manitoba, you'll need to plate the vehicle.
Okay. Referring again to your scenario of the insurance coverage and what you should have been carrying and what you actually were carrying, and is this not what has made necessary the need of these assessment companies that come around and assess your properties in your community?
Partially true, yeah.
Exactly.
The co-insurance penalty typically comes into play in a partial loss, not necessarily in a total loss, but the danger in a total loss is if you're going to insure it to $900,000, that's all you will collect on the insurance policy. That's the limit of the policy. So it's not so much for the co-insurance provision, but for that absolute total loss that you need to be insuring to a correct value. And the value, too, is like the example I gave with guaranteed replacement costs. If you're sitting there at the council table and you're coming up with your best guess, if you're too high, you're wasting insurance dollars.
Okay, thank you.